Hey everyone, Chris here. Thanks for checking out the podcast. If you're enjoying it and learning something along with us, please consider becoming a supporting patron at patreon.com/ateachershistory. Or you could leave a rating and review on iTunes. It would be a huge help. If you'd like to raise your hand and participate along with us, you can find us on Facebook, Twitter, @ateachershistory, or shoot me an email, chris@ateachershistory.com. All right, let's get on to the next episode. Hello, and welcome to A Teacher's History of the United States. Thanks so much for joining us again today. Did you know that just like the Constitution, the Bill of Rights was pretty much written almost entirely by James Madison?
Did you know that of the 17 initially proposed amendments by James Madison, one of them became part of the Constitution over 200 years later?
And did you know that the Bill of Rights did not initially protect us from the state government's ability to infringe upon our right to religion, speech, and due process? Did you know all of this? Maybe, maybe not. Get your notebooks out because today we will talk about that and more in episode 80, Extra Credit, Madison's Bill of Rights. Hello, and welcome back into the podcast. Another Extra Credit episode, and I am pleased to welcome back after a long holiday hiatus, Mr. Bill Gorman. Welcome back to the pod, Bill.
Chris, fellow history nerds, it is a pleasure to be back.
It's good to have you. This is your first post-revolution episode, correct?
It is, and first of 2019, so we got some firsts today, but I'm ready to jump back in.
Great. Awesome. Today, we are diving into the Bill of Rights, which a former AP government teacher like myself loves this stuff, and a legal nerd like Bill also love it. You probably like it even more than me, huh?
I eat this stuff up, man. Yeah. It's a little weird. But I want to jump right into it. So, Bill, I would like to begin, and we're going to dive into a bunch of stuff on the Bill of Rights today. But I would like to begin with sort of providing you some background, tying the thread between last episode in which we talked about the ratification process, and then today in which we'll dive deeper into the Bill of Rights. We'll cover some of the specifics. We'll talk about something called the doctrine of incorporation, which many of you may have never heard of, and you may not realize how big of a deal it really is. And then we'll even talk about a couple of the amendments that weren't passed originally and what ended up happening with them. Anything else to add there, Bill? Or does that sound like a good slate? Nope, that's good. Let's do it.
Great. So last week we left off in episode 79 with the ratification of the Constitution. And I discussed how the lack of this Bill of Rights, which we'll talk about today, was a pretty significant impediment to the eventual ratification of the Constitution. Back in Philadelphia, during the convention, on September 12th, George Mason, in fact, mentioned that there should be a Bill of Rights, and Elbridge Gerry, if you recall, specifically mentioned its absence as a reason why he would not sign the document. But to many, this attempt to add a Bill of Rights seemed like a delay tactic more than anything else, and was quickly and easily voted down in the fall of 1787, or technically, I guess, the late summer of 1787. I also discussed last week how the argument during the convention, and especially during the ratification process into 1788 and then 89, held that if the Constitution did not specifically give the federal government certain powers, then they didn't have them. This was one of the Federalists' go-to arguments, Hamilton's especially. Thus, there was really no need to include an enumerated Bill of Rights. If the Constitution doesn't say the government can do it, then the government can't do it. What's there to be afraid of?
What many of these men found out, though, was that omitting a Bill of Rights made ratification of the Constitution a lot harder than it needed to be. Pulitzer Prize-winning historian Jack Rakove of Stanford called this omission, quote, the one serious miscalculation the framers made as they looked ahead to the struggle over ratification. And we talked about this last week with many of the arguments from the Anti-Federalists not having this Bill of Rights screamed of tyranny and set the people up to be taken advantage of in their minds as quickly as almost immediately following ratification. In response to this, we know that the Federalists contended that not only did these rights not need to be enumerated in the Constitution, like I mentioned, but also that each state had their own Bill of Rights. So why was it so necessary for the federal government to have one also? As we now know, in December of 1787 and into January of 1788, like I talked about at the end of the episode last week, 5 states ratified the Constitution without too much trouble, except for some really angry people in Pennsylvania. But there was still a lot of work to be done. 8 more states needed to ratify in order to have all 13. And actually, during the ratification process, Vermont technically becomes a state. So then there are 14 when we're talking about ratifying the Bill of Rights. But we know they only needed 9. So they only needed 4 more states. But for it really to be united, they needed 8 more states to ratify. And it was becoming very clear that in order to have a united nation, a Bill of Rights was becoming more and more necessary. The realization hit home, and once again, we mentioned this in last week's episode 79, when 2 of the Massachusetts Anti-Federalist superstars, Samuel Adams and John Hancock, agreed to vote for ratification only if there was a Bill of Rights added to the existing Constitution. Virginia and New York then later made similar demands, and it became clear that the only way this was going to work is if guarantees of a Bill of Rights were made and accepted. Interestingly enough, this Bill of Rights would be essential not just to the future of the U.S., but also to Madison personally. I've always found this little tidbit pretty fascinating, especially considering what we know now about American history. The Virginia House of Delegates, led by Madison's personal enemy, Patrick Henry, the man who smelled a rat in Philadelphia, gerrymandered Madison's district so badly that his election was threatened. They recruited another person to run against James Madison, a guy named James Monroe, who actually would become James Madison's Secretary of State and be the president following James Madison. Pretty incredible stuff. And they recruited this man, James Monroe, to run against Madison. I mean, how embarrassing would that have been if Madison more or less wrote the Constitution and then was not elected to the House of Representatives? Madison was only able to win his election to Congress and defeat his future friend, James Monroe, by guaranteeing that he personally would introduce a list of amendments to the Constitution. And Madison had come around to this idea in a genuine way, although, of course, the threat of losing election, I'm sure, helped push him in that direction. During the ratification debates, he realized how important it was to the people, and the last thing he wanted was for all of his work from 1787 to become undone. I'm sure he was having many sleepless nights in 1788 during the ratification process, wondering how big of a mistake they had made by not including a Bill of Rights. Madison wrote to Thomas Jefferson that, quote, the friends of the Constitution, some from an approbation of particular amendments, others from a spirit of conciliation, are generally agreed that the system should be revised. But they wish the revival to be carried no farther than to apply additional guards for liberty. In the end, though, historians debate how much he personally believed in them in a vacuum. As he wrote, quote, Bill of Rights, useful, not essential. Washington was on board too. In his inauguration to the presidency, prior to any type of proposal for amendments, he wrote, whilst you carefully avoid every alteration which might endanger the benefits of an united and effective government, or which ought to await the future lessons of experience, of reverence for the characteristic rights of freemen and of regard for public harmony, will sufficiently influence your deliberations on the question how far the former can be impregnably fortified, or the latter be safely and advantageously promoted. Naturally, as we would expect, Madison did his homework when preparing for these proposed amendments, going as far back as studying the Magna Carta from 1215, the English Bill of Rights from the late 17th century, and the existing state constitutions from the United States of America. On June 8th, 1789, after 3 months of being a nation at this point, James Madison once again took the responsibility of steering our nation in the right direction, proposing 17 amendments. And actually, technically, he sort of proposed 20, which was then narrowed down to 17. And these 17 were approved by the House. Roger Sherman of Connecticut convinced the House, while they were in these deliberations, that these amendments needed to be added to the end of the document, so it remained original, even though Madison had proposed inserting them throughout, which I've always found interesting, and being a history teacher, I very much appreciate that, because that would have been a royal pain to have to sift through the Constitution to find all of the added amendments. On October 24th, 1789, these 17 amendments were passed on to the Senate. After a month of debate, the two houses then agreed to send 12 amendments to the states on September 25th, 1789. And this doesn't mean they removed 5 of Madison's proposals. In reality, they more or less just condensed his 17 proposed amendments to 12, while more or less maintaining all of his original intent and content. In the end, the process seemed to be incredibly useful because throughout this process, a lot of men, they actually changed their personal views on the insertion of a Bill of Rights. They were like, actually, this is probably a pretty good idea. It's good that we're doing this, which really took a lot of ammunition away from the anti-federalists because the quickest way to get someone to stop screaming and yelling at you is to agree with them. Just like at the Constitutional Convention, James Madison was the brainchild of the Bill of Rights too, because of course he was. And we can see pretty clearly now why he has been given the nickname, the Father of the Constitution. Historian Gordon Wood chimed in by claiming that, quote, there is no question that it was Madison's personal prestige and his dogged persistence that saw the amendments through the Congress. There might have been a federal constitution without Madison, but certainly no Bill of Rights. And that sets us up for our conversation today on the Bill of Rights, a couple specific amendments that we'd like to talk about, and some other interesting facts. So, Bill.
All right, now let's talk about why these Bill of Rights are so important. To me, the lasting legacy of the Bill of Rights is that it forced the framers to have a debate over collective versus individual rights. Big government, quote unquote, big government versus quote unquote, limited government. That does not mean that debate ended in 1791. However, having that foundation set does level expectations. For a little perspective on what I just said, I'd like to go through just a couple arguments with you. Robert Whitehill rose to speak at the Pennsylvania Ratifying Convention in November 1787 and argued that restraints must be put on the mechanisms of power. What were those mechanisms? In Mr. Whitehill's opinion, a Bill of Rights. But in Federalist number 10, as Chris talked about on his previous episodes, James Madison wrote, it is by the very nature of the Confederation of States that will be the restraint on that mechanism of power. Madison wrote that due to the disparate interests from person to person, faction to faction, and state to state, concentrated power will be unlikely, as there will be a necessity for coalition building and ultimately compromise.
And this really hammered home to Madison's entire general theme is that the people will check each other.
Correct.
Through this
But
government of myriad interests.
Not everyone simply agreed, as you pointed out. Not everyone was on Madison's side on this. Most notably, as you said, his Virginian foe, Patrick Henry, an anti-federalist. He was speaking at the Virginia Convention in June of 1788 to advocate for the necessity of a Bill of Rights. He rose to speak and said, "The powers of direct taxation, the sword, and the purse. You have disposed of them to Congress without a Bill of Rights, without check, limitation, or control. Still you keep barriers. Pointed where? Pointed against your weakened, prostrated, enervated state government. You have a Bill of Rights to defend you against the state government, which is bereaved of all power. And yet you have none against Congress, though in full and exclusive possession of all power. You arm yourselves against the weak and defenseless and expose yourselves naked to the armed and powerful. Is not this a conduct of unexampled absurdity? Counterpoint, Alexander Hamilton in Federalist number 84 posited that bills of rights are not only unnecessary, but would even be dangerous. And he says, "For why declare that things shall not be done, which there is no power to do? Why, for instance, should it be said that the liberty of the press shall not be restrained, when no power is given by which restrictions may be imposed?" As Chris just went through, a lot of folks saw the light on whether or not a Bill of Rights was prudent. But I think the lasting importance of the Bill of Rights was the debate that all of these thinkers, these titans of their time, had to wrestle with. And so that is my philosophical take on why the Bill of Rights were so important. My pragmatic take on the Bill of Rights and why they were so important is that if they were not included shortly after the ratification of the Constitution, the Anti-Federalists would have entered into an open revolt. And so, yeah.
Yeah, so that's pretty important. And also, if there weren't, because many of the, like Massachusetts, Virginia, New York, etc., they ratified the Constitution under this gentleman's agreement. And if it wasn't done, and it wasn't done in an expedient manner, I think you're correct, Bill. The Constitution as we know it today would not have continued to exist. It would have changed in some way. And while I love Madison, and I like Hamilton a lot too, I think that history has shown that those who advocated for the Bill of Rights definitely have fallen, at least so far. And I don't think things will change much in the future on the right side of history. The idea that if the federal government doesn't have the explicit power to do it, it can't possibly be done, seems like a foolish argument considering everything we know about what's happened over the past 200 plus years. So Hamilton sort of swung and missed there. But nonetheless, and I talked about it last week, how incredibly well-written and powerful the Federalist Papers were, even if maybe they weren't as influential as people initially thought they were when studying them after the fact. So I mentioned Madison began with basically 20 proposals and then became 17 amendments, and then that was condensed down to 12 different amendments, and that's because they took, like freedom of speech and press and then combined it with freedom of religion in one amendment, and then they took the right to a jury trial and then the right to due process and combined them. So all of Madison's ideas were there, but in the end, 12 amendments were officially proposed to the states and only 10 of them passed. Therefore, obviously, there were 2 amendments that were proposed that did not pass at that time in 1789. And interestingly enough, and we talked about this in the lead-in, Bill, do you know which number amendment is now passed today that was proposed over 200 years ago?
I do. It's the 27th Amendment.
Yes, very good. And the 27th Amendment, and I'd like everyone to listen to this because this is a pretty incredible story. The 27th Amendment is pretty logical amendment. It says that if Congress is to give itself a raise, it can't take effect until the next congressional session. Now, I did not do quite enough research to know why the states in the late 18th century did not find it necessary to pass this one, but it was passed in 1992. Yeah, you heard that right. 1992, over 200 years after it was originally proposed, the 27th Amendment was passed. And get this, in 1982, a man named Gregory Watson, he was a sophomore at the University of Texas, Austin, and he needed a topic for a course paper. And he found out And I don't know why he was looking into this, but he found out that this proposed amendment could technically still be passed. There was no expiration date for it. And to him, it seemed pretty logical. If you're going to give yourself a raise, you have to win the election in order to earn that raise. Funny enough, he wrote a term paper on all of this, and he received a C grade from his professor. And when asked about it, Watson said, quote, "The professor gave me a C on the paper. When I protested, she said I had not convinced her the amendment was still pending." Well, he would convince her soon enough, because using a grassroots campaign, he began to reach out to individual states. He found out that actually like 5 or 6 states had already passed it, so he didn't need to reach out to them. They'd already voted on it and approved it. So he actually got enough states to vote on this and approve the amendment. In 1992, an amendment that was originally proposed by James Madison in 1789 was passed. It was then, of course, at this point when people were like, wait, what state just voted? Wait, how many states voted? We have a new amendment? How did that happen? And they went and checked and to make sure that this was done in a proper way and there's nothing unconstitutional about this process. And after doing their due diligence, they found out it was constitutional. And one of the 12 proposed amendments from 1789 that was not passed was passed and approved and ratified in 1992. And that is today the 27th Amendment and the most recent amendment to our Constitution. The other amendment that did not pass was Amendment on Constitutional Apportionment. And this was an amendment that laid out a mathematical formula for determining the number of seats in the House of Representatives. It would initially have required one representative for every 30,000 constituents, with that number eventually climbing to one for every 50,000. As the amendment was never passed, Congress has set the size of the House of Representatives by statute. So throughout the 19th century, the 1800s, the House continually gained new members, but with one brief exception, there have been 435 voting members in the House of Representatives since the passage of the Apportionment Act in 1911. So the two amendments that were proposed by James Madison in 1789 that were not passed, one of them did pass, and the other one is now a law. It's a statute. So more or less, everything that James Madison came up with in those 17 amendments were then added to the document that he was largely responsible for crafting in the first place, which is why I termed this episode Madison's Bill of Rights. And the guy is incredible, and the debt that this country owes to him and his brain and his nerding out on government for years is can't be overstated. Additionally, as I'm saying this out loud, I realized a few episodes I mentioned that there are 537 votes in the Electoral College, and I'm now realizing there are 535. Right, Bill? Bill, you're looking at me with a quizzical look.
It's 435 from the House and 100 from
and 100
the Senate.
from the Senate. Yeah, so 535. Okay, so I misspoke a few episodes ago. So if you listen to that episode and you're like, God, Chris is an idiot. It's 535, not 537.
There are 537 elected officials in the federal government.
Yes, that's very true. And why is that, Bill?
Well, you have the 435 from the House, the 100 from the Senate, and then the president and vice president are both elected. Gives you the other two.
Yep, very good. So let's dive into these Bill of Rights that Madison was so responsible for writing. And we'll go through them, and some of them we'll go through briefly, and others we have a couple thoughts on. Number one, and this is the amendment that actually was a couple different amendments originally posed by Madison put together into one. I'm not totally sure why they put them all together, but I think it has a nice ring to it. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for redress of grievances. So, freedom of religion, speech, and press.
This one's obviously targeting those liberal values that that's liberal lowercase l, liberal values that the British Parliament took away in the years building up to the Revolution, right, Chris?
Yes, absolutely, 100%. And what we've seen throughout U.S. history is these have come under attack quite often. Like I mentioned earlier in the episode, I taught AP U.S. Government and Politics, in which we go through all of the landmark cases throughout U.S. history that have to deal specifically with freedom of religion, speech, and press. And there have been quite a few times when the freedom of press has been restricted by state or federal governments, and also freedom of religion and freedom of speech. I would like to point out that religion is a little tricky because it says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Basically saying that you are allowed to exercise your religion in however way you want. And on top of that, the federal government cannot endorse any specific religion using their property, their money, their speech, etc. And we've seen different cases throughout history with like a nativity scene or what's often called a creche. There's one specific case where there's a creche on the courthouse steps. Well, you can't really have a nativity scene with Jesus Christ and Mary on the steps of federal property. You can't do that. And seeing as we were founded as a overwhelmingly Christian nation, you can understand why the Establishment Clause in the First Amendment has been a pretty controversial one for many people over the years. And that brings us to Amendment number 2, which is the right to bear arms. Quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And this is the amendment that is probably caused the most controversy over the past couple hundred years of American history. And I really wish the Founding Fathers had gone back and added a bit more detail to this one. It would make all of our lives a lot easier as to what specifically they intended and why they wrote it in the first place. And I do, before we talk about this one or any others, I do want to point out that Bill and I are not trying to promote any type of specific political leaning. While Bill is not, I am more or less apolitical, and I don't really care one way or the other with certain issues. But in case your blood pressure is starting to go up, please know that we're not here to do that. But Bill, I know you wanted to talk in a bit more detail about the Second Amendment.
Yeah, and you kind of hit the nail right on the head about why. There's no more hotly debated piece of the Bill of Rights, certainly to this day, like right now, than the Second Amendment. And I think that may be because even at the time of its conception, there was ambiguity around the type of freedom or liberty it was guaranteeing. I found a Valparaiso Law Review article suggesting that the Second Amendment was, from its adoption, designed to ensure both the individual's right to self-defense and the people's right to oppose a tyrannical government. However, there's Professor of Law Adam Winkler out at UCLA who suggests that the framers were concerned about self-defense, but it was within the context of armed state militias that would exist to prevent federal overreach. Alexander Hamilton would have to agree, calling a well-regulated militia the most natural defense of a free country.
And that makes sense. I mean, from Hamilton's perspective, he just fought in a war in which the winning side fought primarily with a not so well-regulated militia defeating the most powerful country in the world. So at this point, with the lack of technology, no planes, no tanks, no nukes, no drones, it actually seemed like a well-regulated militia could put up a pretty good defense against some type of tyrannical government because they're on even playing fields.
Right. And I get it. I get so the context around it, what you're saying is there's a tyrannical government. These folks, these framers, were coming off of a period in time where they remembered when our old foe, General Thomas Gage, de-armed the colonists in 1775. They remember.
How dare you bring up Gage's name again? I'm done with that guy.
They remembered where the British soldiers were marching to as they moved on Lexington and conquered munition stores. The framers saw the danger in standing armies that were at the beck and whim of a national government. Professor Noah Schusterman claims that preventing the United States from starting a professional army was the single most important goal of the Second Amendment. Interesting thought. Over the course of time, other scholarship, other writings have pointed to westward expansion and the...
Yeah, I'm glad you're mentioning that. I was about to mention that I know westward expansion was top of mind for many people at this time too, and some, of course, argue with varying degree to how important.
If you want to learn, if the listener wants to learn more about the notion that the Second Amendment was really about westward expansion and ultimately about the frontiersman's ability to, for lack of a better word, eradicate the Native American population, author and historian Roxanne Dunbar Ortiz has been the one who literally has written a book about this. Needless to say, there are varying opinions for what the Second Amendment is intended to do and for whom the protection applies. Obviously, Chris, we could spend all day about how the Bill of Rights only applied to a certain set of citizens, right? And who could be a citizen. That said, the Supreme Court has somewhat settled that for us, where in 2008, and we're jumping way ahead in time from when when the Second Amendment was ratified.
Yeah, I'd say.
For the first time, it was in 2008, where the Supreme Court ruled that the Second Amendment does protect an individual's right to bear arms for self-defense. So even though we have all of this academic thought, all of this interpretation, ultimately the Supreme Court, of course, is the grand arbiter of the Constitution.
Yeah, and that was over 200 years later.
Correct.
Yeah, 220-ish years later. Yeah, and I think that, one thing that's interesting for me personally is that I have now lived half of my life on the eastern shore of Maryland, which is very rural. I grew up in a little development, but I was basically surrounded by farmland. I grew up in the one district in the state of Maryland that votes overwhelmingly Republican every election. I went to a high school in which people had Confederate flags in the back of their pickup truck as they pulled up to school. I went to a Catholic school, so we would have our out-of-uniform days, and when we donated $1 to whatever charity, and there would be dozens of people wearing camo hunting gear to school for their out-of-uniform days, because more or less that was the only other clothing that they had. And then I went from that environment to living in the city of Cincinnati, and then living in the city of Baltimore now, which is, the murder capital of America, although I absolutely love it here. The violence can be pretty bad. And it is interesting to see the different views on guns and gun ownership and the impact that it has in communities, in the rural areas and in urban areas. And I can tell you that, especially a lot of people I know who very much support the Second Amendment, it is far more cultural than I think the founding fathers thought it would ever become. The idea, you have men and women who hunt, and they hunt regularly, and their parents hunted with them when they were children, and their grandfathers hunted, and it is a family tradition. And so this right to bear arms is so much more than just the right to own a gun for the sake of owning a gun. I also think in a lot of these more rural areas where you don't have a lot of gun violence, now that I've lived in city for the past 15 years, whether it be Cincinnati or Baltimore, I speak to a lot of people I know who are still in these rural areas, and they just don't experience the violence that comes from guns and the incredible amount of deaths. I mean, Baltimore has over 300 deaths a year by guns. And so they don't experience it. Like back where I grew up, like people don't die. People aren't murdered. Like people don't die, and everyone owns a gun, and pretty much no one's murdered by a gun. So I think that, like everything in life, life is nuanced. politics is nuanced, and people's beliefs, individual beliefs on certain issues are very nuanced. And so I think understanding that, or even if you don't understand it, accepting that that's a true statement, helps to begin conversations around very difficult issues like these, and how to deal with them, as opposed to demonizing the other side one way or the other, which really usually doesn't get us too far. But yeah, the Second Amendment is not going away anytime soon, and the arguments over it, I am sure, is not going away anytime soon. And that brings us to Amendment number 3. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. That one's pretty straightforward. One thing that was often surprising when I taught this in school is that it says, nor in time of war, but in a manner to be prescribed by law, which means that you actually were not free from soldiers being housed in your home, because during a time of war, the federal government could just decide that they wanted to do it, and they could do it anyway. It just couldn't happen in peacetime. So really, it's against this idea of a standing army, which is an infringement upon the psychological health of a community. Then we have Amendment number 4. This one is incredibly important, as is number 5. Amendment number 4 is protection from unreasonable searches and seizures. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. And this has developed through the Supreme Court more specifics. I know, Bill, you're familiar with the exclusionary rule. And with the exclusionary doctrine, it basically says that if the police or some type of authority figure comes in and gathers evidence against you, but does so in an illegal search that violates this Fourth Amendment, that it's excluded from the proceedings. They can't use it against you, which has come in handy for many criminals over the years. And then you have the plain view doctrine, which, if a cop, and look, I'm not a legal scholar here, I just pretended to be one in front of a room of teenagers. But if a cop were to go into a home and he had a probable cause, and he had a search warrant for, say, an illegal weapon, and he went into the home and there's like a meth laboratory in the home, and he just walks right into it, he can't be like, oh, nope, I can't do anything about that. I'm here for an illegal weapon, so just keep cooking your meth. That's the plain view doctrine, right? If something illegal is happening in plain view of an officer while they're there executing a legal search warrant, then that can be admitted. So the Fourth Amendment, I always thought teaching it was the most fun out of all of the amendments because of all of the entertaining court cases, but it's incredibly important because it gives the individual citizen peace of mind that the local authority figures cannot infringe upon their rights, cannot harass them, cannot destroy their property through these unreasonable searches and seizures, cannot infringe upon their privacy, which is so incredibly important. And then we have Amendment number 5, protection of rights, life, liberty, and property. It says no person shall be held to answer for a capital or otherwise infamous crime unless on a presentation or indictment of a grand jury, except in cases arising in the land or naval forces in the militia, when in actual service time, in time of war or public danger. Nor shall any person be subject for the same offense twice put in jeopardy of life or limb, which is an incredibly important clause, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of the law, nor shall private property be taken for public use without just compensation. Amendment number 5 is loaded with stuff.
It also happens to be loaded with part of the justification for how the framers dodged the issue of slavery.
Yeah, I mean, when you have the right to property, well, this makes it all far more complicated moving forward because you have nor shall private property, which at this time technically was defined, slaves were private property. So this was something that that pro-slavery advocates moving forward are able to really hang on to in saying, it says right here, nor shall private property be taken for public use without just compensation. So you can't take it. This is also where eminent domain comes in. If the federal government wants to take your land, they have to pay you for it. Quote, just compensation. Of course, that takes out like all of the nostalgic value of like having your home taken to build a highway. If you live in a crappy home, they're going to give you the pricing of a crappy home, even if you've lived there for 70 years. They don't care.
Double jeopardy?
But yeah, double jeopardy.
I'm sorry,
huge.
What is double jeopardy?
Oh, what is double jeopardy? Yeah, I like it. Double jeopardy, this idea that you cannot be tried twice for the same crime, which we know is really important. We take that for granted today, but think about it this way. You were tried for, let's just jump to the most serious offense, murder, right? You're tried for murder, and the prosecutors try you, and you get off. Not off, you are found not guilty of the crime. Well, what a lot of people don't realize when they watch these crime documentaries and these people who are falsely accused and then they get off, or people who maybe are justly accused and are found not guilty. And I know this being the son of an attorney. Attorney's fees, and Bill, you can attest to this, are incredibly cumbersome. And the one huge disadvantage that the individual has against the state is the individual has to pay an attorney to do all the research, to bring in all the experts, to prepare, to argue, all of that. Whereas the state can hire at times 2, 3, assign 2, 3, 4 attorneys. It's all being paid with taxpayer dollars. It's all on salary. And so a lot of times these cases can bankrupt individuals, totally bankrupt them. And so the idea that if you could they could be found not guilty and then you could just walk right out of the courtroom and be like, okay, we're going to do it all over again. And they could just keep doing it and keep doing it and keep doing it. And so the idea of double jeopardy is incredibly important. Once you're found not guilty of a crime, you can't be charged for it
That
again.
was actually an Office reference, but that's okay. I appreciate you explaining that already.
Oh, it was. Yeah. Yes, very
so
good.
So for you
very
fans
good.
of The Office, I hope you appreciated that. Chris did not.
Yeah. Well, no, I didn't pick up on that. But double jeopardy is the reason why O.J. Simpson was allowed to.
But they got him in civil court. So that's double jeopardy does not apply in the civil realm. So that's how the Brown family got, I guess, quote unquote justice. Not making any value judgments there, but that's how they were able to seek another route to a punitive judgment.
Yep. And but that's okay. OJ took care of that by, I'm pretty sure, kidnapping someone at gunpoint. And then he also tried to steal some of his memorabilia from a museum, I think. So he
was a complicated man.
But yes, he was. So don't worry, he still went to prison. And then the last part of the Fifth Amendment is I plead the Fifth. No one can be compelled in a criminal case to be a witness against himself. So pleading the Fifth, that's what that comes from. If you think that something you might say could harm you in some way in future proceedings, you can plead the Fifth. And famously, Mark McGuire in the steroid hearings pleaded the Fifth for like an hour straight, which just made him look incredibly guilty.
You know why that is, though? Because the second...
that and the fact that he's built like the Hulk.
Well, when the second you start to talk, you waive your Fifth Amendment rights. So you have to maintain. That. So that's likely why.
Gotcha. Okay, that was incredibly frustrating. But anyway, so that's the Fifth Amendment. Fifth Amendment is absolutely loaded. The Sixth Amendment, and we'll pick up the speed here. Sixth Amendment, in all criminal prosecutions, and this is the rights of accused people in criminal cases. This is where you get right to a speedy and public trial by an impartial jury of the state, district where the crime's been committed. And this is where you are allowed to get witnesses in your favor and have the assistance of counsel for defense, so the right to a lawyer. The Seventh Amendment.
Can I jump in real quick, Chris?
Yeah, sure. 3, 2, 1.
Now, I'd like to interject because as you go through your head the Third, Fourth, Fifth, and Sixth Amendments, I want you to crawl back to the recesses of your memory where Chris and I addressed the intolerable acts. And I think I said something at the time where I said there would be an airing of grievances towards these. And this, I believe the Third, Fourth, Fifth, and Sixth Amendments would be the chickens coming home to roost, so to speak. Would you agree, Chris? Yeah.
Yes.
So I just want to tie that bow on what has been a fairly long arc. But the Third, Fourth, Fifth, and Sixth Amendments, go back and cross-examine them with the intolerable acts and see where you come down in terms of drawing parallels in Mr. Madison's logic.
Yeah, we're about 25 years later here, and now the Founding Fathers are laying out. These are through the Fourth through Seventh Amendments. These are all the different ways we got screwed 25 years ago. And so we are going to make sure that our own federal government cannot screw over our people in the same way. Unreasonable searches and seizures, right to life, liberty, and property, accuse people in criminal cases.
The British Army just putting a dude in your house. I mean, that's so that's weird. Writs of assistance, remember those? I mean, just
the amount of due process that, I mean, they could, it was pretty bad. The Seventh Amendment basically takes the Sixth Amendment and applies a lot of it to common law, civil law. It says in suits at common law, where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved, so you can get trial by a jury in civil cases. And no fact tried by a jury shall be otherwise re-examined in any court in the U.S. according to the rules of common law. And I would just like take one moment and describe to people the difference between criminal law and common law, because this was a question I would get a lot when I would teach about this stuff. And criminal law is more or less if you have committed an offense against society, so to speak, right? So assault and battery against another person. It is the government's job to protect individuals within the nation from others assaulting them and beating them up. Any type of crime like a DUI is criminal law, right? You are actually threatening other citizens in our society when you do something like drive under the influence. So that's criminal law. Civil law is usually when you do something that directly or indirectly causes damages to another individual, but isn't like a threat against society, so to speak. So we mentioned O.J. Simpson. He was tried in criminal law and civil law. He lost in criminal law, or he won in the criminal trial, and he lost in the civil trial. So if I were to, slander Bill in some way, he could sue me for damages, and that would be in common law or civil law. It would not be in criminal law. Now, I could still be tried for some type of crime if I commit a crime, but when Bill brings me to suit, it would be in civil law. Is this all making sense,
yes.
Bill?
Yes. But okay. You've defamed me many times, so I feel like I've waived any right to bring civil suit against you. That's
true. And one more thing I'd like to point out. In criminal law, it is beyond a reasonable doubt. None of these have percentages, but beyond a reasonable doubt would be like somewhere between 95 and 99%. So if you are a juror, and those are numbers I just threw out there, but I hear them mentioned often. If you're a juror in a criminal trial, like a murder case, right, you have to be, in theory, incredibly sure that that person most likely committed this crime. Beyond any reasonable doubt, meaning that the defense could not bring up any excuse that could cause you to doubt it in any way. Common law is very different. Common law is preponderance of evidence, and that's usually viewed as like a 50-50-ish proposition. Yeah, more likely than not, which literally could be 51% to 49%. So that's why you see, I'm glad we brought up OJ because he is a perfect example. He won in criminal law, but he lost in civil law because if you look at that evidence, it is pretty clear that there's, 51% chance he did it. Yeah, I'd say so. 98% chance he did it. The jury didn't think so. So that brings us to Amendment 8, no excessive bail, fines, and punishments. So this is where we have no cruel and unusual punishment. You can't give excessive fines to people. I can't get pulled over for going 10 miles over the speed limit and get a $5,000 fine and bankrupt me. I can't be thrown into prison and hung upside down by my toes for the rest of my life for a crime I committed. Right? No cruel and unusual punishment. And of course, that's a hotly debated topic. And then Amendment 9 talks about other rights kept by the people. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So basically it's saying, look, if there's something here that is a right of the people that we haven't mentioned, you can't take that away just because we didn't bring it up. And then number 10, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Basically, what this is saying is that in the end, this is a federalist system. The national government and the state government share power, and anything not here in this Constitution, any other powers are given to the states. And I think that that's really, Bill, a perfect segue to bring us into our last topic we'll talk about here for a bit, and that is the idea of the doctrine of incorporation. And if you've never heard the doctrine of incorporation, I would hang on and listen to this because it is really interesting. And usually when I would teach about it, my students were like, wait, what? Really? So let's dive into this. Bill, what is the doctrine of incorporation, and basically what does that say about our Bill of Rights when they were originally written?
Well, Chris, you teased this at the top of the episode in the Did You Knows. It's something that I don't think a lot of folks are really aware of. Doctrine of incorporation. We just spent a decent chunk of time talking about the first 10 amendments to the United States Constitution. We talked about why they came to exist in the first place, what tensions existed between the political factions that drove their creation, and textual conclusions, and we've talked about why they are important. What we have not explicitly addressed, what likely the majority of people are unaware of, was that the Bill of Rights was only to apply to the federal government and federal courts. That's right. The Constitution, as Chris spoke about on the previous 2 or 3 episodes, was created to provide for a stronger federal government after the failed experiment with the Articles of Confederation, but also embraced the idea of federalism, which Chris just defined. I know what you were likely thinking. Wait a second, Bill and Chris. I know that my state government is not allowed to infringe on my First Amendment rights to freely exercise my religion or peaceably assemble.
But they could in 1789. That's right.
And to that I would say, you are generally correct. That said, it was not always that way, as Chris just alluded to. The con law nerd in me will point you to Barron v. Baltimore in 1833.
Barron had a wharf
in the Inner Harbor. Beautiful now, beautiful.
Yep.
But it was a swamp in 1833. And in Barron v. Baltimore, the Supreme Court held that the Fifth Amendment takings clause only applied to the government of the United States and not to the legislation of the particular states themselves. Really, it wasn't until the passage of the 14th Amendment, which stated that no state shall deprive any person of life, liberty, or property without due process of law. This is known as the Second Due Process Clause. Most would say that there are 2 schools of thought to how the Bill of Rights would then apply to the states and state laws. The first would be total incorporation. That is to say, this list of 10 amendments, by virtue of the 14th Amendment's Due Process Clause, must be applied equally to the states. All of them, all in. However, that is not the prevailing opinion, and it is certainly not how the United States Supreme Court has interpreted the Constitution. Instead, the Supreme Court has mostly embraced the doctrine of selective incorporation. Selective incorporation is predicated upon the idea that the 14th Amendment incorporates certain fundamental provisions, but not other non-fundamental provisions.
So basically, what it's saying is that the Bill of Rights existed to protect you from the infringement upon these rights by the federal government, but nothing in the Constitution says that, like, the state can't take away your right to freedom of speech,
and as
the right to
exactly, and as you addressed, more and more states at that time were adopting their own Bill of Rights. So you likely would have been covered, but that you're exactly right. At the start, this was only to be applied to the federal government, to what laws Congress would pass.
And to be fair, that's the only government people were afraid of infringing upon their rights. They had more of a role in the state government, and they weren't afraid of the state. The state government protected them.
I think the framers feared government in general, but I know where you're going, and I think that's right. But I do want to finish the talk about the doctrine of incorporation with two examples about how it actually was applied. So the first is the seminal case in criminal procedure law, Gideon v. Wainwright. It is a seminal case in Sixth Amendment jurisprudence, most assuredly, but also criminal procedure generally. A quick background on this. Previously, the Supreme Court in Betts v. Brady, 1942, stated that the Sixth Amendment only applies to trials in federal court, and therefore the concept of due process of law incorporated in the 14th Amendment does not obligate the states, whatever may be their own views, to furnish counsel in every criminal case in which accused is unable to obtain counsel. Flash forward to 1963. The court in Gideon directly overturned that prior ruling in Betts and came to the conclusion that the Sixth Amendment to the federal Constitution, providing that in all criminal prosecutions, the accused shall enjoy right to assistance of counsel for his defense, is made obligatory on the states through the 14th Amendment. The Gideon court believed that the right to counsel is a fundamental safeguard of liberty. Therefore, they saw fit to selectively incorporate the Sixth Amendment to the states. That decision was unanimous.
Yeah, and that, so a couple things here, basically to break it down, in even more simpler terms, Gideon was charged with, I believe, breaking and entering with intent to commit a misdemeanor, which in Florida is a felony. I think he broke into like a pool hall or something. And then he had to go into court and defend himself. And this is a guy who had an 8th grade he was an older man with an 8th grade education. And so he was like calling his own witnesses. He was cross-examining. And at the very beginning of the trial, he asked the judge if he could have a lawyer. And the judge said no. Because under the Florida state law, you were not guaranteed the right to representation. He was an indigent. He had no money. He could not afford a lawyer. And so, no joke, he wrote to the Supreme Court from his jail cell. He did all the research, and he wrote a letter handwritten to the Supreme Court, and they granted him writ of certiorari and heard his case. And that really was the groundbreaking case to bring a lot more attention to this idea of selective incorporation, which what you're saying, Bill, correct me if I'm wrong, but by selective incorporation, you take individual clauses like one at a time and incorporate them to all the states, as opposed to saying, okay, the entire Bill of Rights now applies to all the states. They're saying, no, this one clause in this one amendment applies to all of the states. And so over time, we've just had a whole bunch of cases that have continued to selectively incorporate most of the Bill of Rights to the
That's
states,
exactly correct. And even amongst Supreme Court justices themselves, they have differed over the years about how to handle this. It's just that the prevailing opinion amongst the most justices in the most majority opinions have been guided by this concept of selective incorporation. Chris, I'm so glad you brought up the part about how Gideon was an indigent defendant. So Gideon v. Wainwright was not only a perfect example for the doctrine of incorporation, but it also highlighted the fact that it cemented indigent people's absolute right to counsel, even though they cannot afford it, that they will be provided counsel. So it was, in that way, it's kind of a twofer example on what rights are guaranteed.
Yeah, and I think it builds upon what I was saying earlier about just how expensive legal defense is. And many people without money and without education already are behind the 8 ball, so to speak, in many ways. And if they can't ever afford to defend themselves in court when they're charged with a crime, it would make things incredibly difficult for a guy like Gideon.
So the second example I have is McDonald v. City of Chicago. We don't have to reach too far back for this one, as McDonald stems from a 2010 Supreme Court decision on the state's ability, in this instance from the City of Chicago, to restrict an individual's Second Amendment rights to keep and bear arms. This decision came 2 years after the court struck down a federal law in the District of Columbia that restricted an individual's right to own a handgun for the purpose of self-defense in the home. That was D.C. v. Heller. The doctrine of incorporation did not come into play in Heller, though, because that was a federal court, and the Second Amendment controlled in the federal realm.
Gotcha.
But McDonald was a state law. So, is the Second Amendment a fundamental right like the court found in Gideon? Well, Justice Alito's logic said yes, it was. And the way he got there was through the idea of self-defense as a basic right. In Supreme Court speak, the Second Amendment right was thought by the ratifiers of the 14th Amendment, quote, among those fundamental rights necessary to our system of ordered liberty, end quote. Alito and his 5-4 majority found the Second Amendment is now fully enforceable against the states.
So up until 2008, the states were not prohibited from passing laws limiting your right to own.
Based on Supreme Court challenges, that's correct. And up until 2008, I'm sorry, that was up until 2010. Up until 2008, the court had never defined that an individual had that fundamental right to bear arms. That was the first time.
That's pretty crazy. Now, are there certain things in the Bill of Rights that still are not incorporated to the states? Like technically, the states could pass laws prohibiting these things from you, and without being unconstitutional.
Yeah, the Cornell Law School has aggregated a pretty impressive list of it. I mean, it's only 10 you got to keep track of, but there's a lot of case law, right? They've divided it into really 3 categories with one then subcategory. The first would be full incorporation. So the first...
Which are the ones that we've talked about.
Yes.
The type of stuff we've talked about.
First, second, fourth amendments fully incorporated. Then the second category would be partial incorporation. The 5th, 6th, and 8th amendments would fall into that bucket. The third would be no incorporation at all, the 3rd and 7th Amendment. And then the 9th and 10th Amendments just don't fall into the concept of incorporation generally, so no cases really have ever come up about that.
So the 3rd and 7th Amendment, so technically a state still today in now 2019 could pass a law forcing you to quarter soldiers in your home. And according to the 7th Amendment, a state could take away your right to a jury trial in state civil law.
Based on my understanding of how these Bill of Rights have been incorporated into and applied to the states, that's correct.
Now, based on precedent, if a state were to do that and you were to sue them for it and take it to the Supreme Court, you have a very good chance of getting that incorporated.
What's the likelihood? I can't speculate on that. But based on the court's history of approaching these piecemeal one at a time, you'd have to think you'd have a shot.
Yeah. Really interesting. I've always been fascinated by the doctrine of incorporation. And I think for me, what makes it most fascinating is they used the 14th Amendment, which was written for a completely different purpose than this one. And by the way, they tried a few different clauses to incorporate these Bill of Rights to the states, and they finally landed on the Due Process Clause, which is perfectly ambiguous enough to basically argue anything under it, and it has worked. Thankfully, At least in my opinion, thankfully, it has worked. So now we have the same seminal protections from our state governments, just like we do our federal government. Bill, anything else to add before we go?
That is it for me, Chris.
Awesome, man. It was good to have you back on a marathon episode on nerding out on the Bill of Rights. And Bill, it was good to have you back, man. I'm looking forward to having you more coming up here in the future. I know you'll be back more involved in Unit 4, and it will be a lot of fun.
This episode made the con law junkie in me just get real high.
Yeah, I know. And you never told the story about how when you were in college and you got the question wrong on doctrine of incorporation, but we'll save that for another day. All right. Well, Bill, thanks for joining me. Listeners, thanks for checking it out. And hopefully now you can take pride in knowing just a little bit more about the history of the United States. Class dismissed.